It fills an important gap in this respect. There are three main aims of this preventive mechanism: to identify potential rule of law problems at an early stage, to do this based on dialogue with each member state, and overall to strengthen the rule of law culture across Europe. This is the first time that the Commission is taking a wider look at rule of law issues across the Union. The report covers 4 pillars: justice systems, anti-corruption frameworks, institutional issues related to checks and balances, media freedom and pluralism. Why these? Because it is relevant to have an overview of these issues and see the links between them, not least because deficiencies often merge into an undrinkable cocktail, even if the individual ingredients seem to be fine. I sometimes hear that the rule of law does not have a concrete definition at the European level. The report already also clearly addresses this, pointing to the Article 2 of the Treaty, to the rulings of the Court of Justice, the Council of Europe or the European Court of Human Rights. The definition that reemerges from this is actually quite comprehensive and, I believe, very logical. It includes the principle of constraints of public powers set by law, independent and impartial courts, legal certainty, separation of powers, equality before the law, and many more. This is all true. But what is also true is that when the rule of law is absent, when it is at risk, there is a concrete impact on every single one of our lives. I know this firsthand because I myself grew up in an authoritarian regime without the rule of law. This means that equality before the law was an illusion. There were people more equal than others. The politically appointed judges did not serve the justice. The media broadcasted propaganda in the service of the ruling party, and we had to listen to Radio Free Europe to search for a different perspective. The European Union was created also as an antidote to those authoritarian tendencies. When it comes to breaches to the rule of law, the European Commission has a clear role to play as guardian of the treaty. And this is why we will also in the future not shy away from launching infringements and continuing the discussion under Article 7. And this is why we also need the multi-annual financial framework conditionality to deal with the rule of law, abuses against the financial interests of the EU. But next to this set of response measures, it is high time to also have a tool to detect rule of law issues early on and to prevent them from happening. The report we are presenting today is a new tool which is going to help us to do so. The report is objective and covers both positive and negative elements and should serve as a basis for a dialogue on rule of law with the member states. The reports were developed in an inclusive process and in close cooperation with the member states, and Didier will elaborate more on this specifically because he was leading the whole process. We treat member states in the same way. The reports are following a coherent structure. Ladies and gentlemen, let me conclude with a quote of Václav Havel that seems very timely to me. The natural disadvantage of democracy is that it is extremely tiring to those who mean it honestly, while it allows almost everything to those who do not take it seriously. And it was the end of the quote, and if I may add something for today, and to those who want to abuse it. Thank you very much.
Thank you very much, Vice President. Commissioner Reinders.
Thank you. Bonjour à tous, tout d'abord, et je voudrais commencer en disant qu'aujourd'hui, c'est une journée importante pour la protection de l'état de droit dans l'Union européenne. Et la publication de ce premier rapport annuel marque un moment charnière, car c'est la première fois que nous présentons une cartographie de la situation de l'état de droit dans chacun des États membres. Les informations qui s'y trouvent ne sont pas nouvelles. Elles sont dans le domaine public. Le mérite de ces rapports est de les avoir collectés et de nous donner une vue d'ensemble de la situation de l'état de droit dans l'Union. Ce rapport représente à mes yeux une source importante d'informations. Elles seront utiles pour les discussions à venir, tant au niveau européen, national et, si on le souhaite, au niveau local. Ce rapport nous permet d'entamer une nouvelle étape dans la protection de l'état de droit et la promotion de la culture de l'état de droit au sein de l'Union européenne. J'ai toujours soutenu que l'état de droit devait être examiné de manière exhaustive et continue. C'est une ambition que j'ai eu l'occasion de porter dans des fonctions antérieures. J'ai toujours été de ceux qui pensaient qu'il ne fallait pas se limiter à examiner seulement certains États membres, mais que nous devions examiner tous les États membres sur un pied d'égalité et en utilisant une méthodologie commune et objective. Si l'état de droit n'est pas respecté dans l'Union, comment pouvons-nous être crédibles lorsque nous évoquons nos valeurs avec les pays candidats ou avec nos partenaires internationaux? Si l'état de droit est en danger, c'est tout l'édifice communautaire qui est en péril. La question de l'état de droit concerne l'Union dans son ensemble, car ce qui se passe dans un État membre a incidence sur tous les autres États membres et on le voit de plus en plus dans un certain nombre de dossiers concrets. Avec ce rapport, nous voulons aborder les problèmes à un stade précoce. C'est l'objectif de cet outil qui vient s'ajouter aux autres moyens dont nous disposons déjà pour assurer le respect de l'état de droit. Today, we are establishing the comprehensive European rule of law mechanism. The heart of this new mechanism is the Commission's rule of law report adopted by the College today. Our report covers both positive and negative developments in the Union, including a country-specific assessment of all 27 member states. I would like to stress that this report makes a clear difference between punctual concerns that we may have in some member states and the systemic issues. The European Rule of Law mechanism, with the Rule of Law report at its centre, will serve to deepen dialogue and joint awareness of the rule of law throughout the European Union. The mechanism is a yearly process during which we aim to prevent problems from emerging or deepening by having open debates and by exchanging best practices. To set up the mechanism, in January I wrote to all the EU ministers to establish a network of national rule of law contact points in every member state. This was instrumental not only as a constant channel of communication with member states, but also to discuss the methodology of our report. On this basis, all 27 member states provided written input. We also carry out a targeted stakeholder consultation where over 200 stakeholders provided written input. These include EU agencies, national and European civil society organisations and professional associations. And we conduct more than 300 virtual country visits. During these visits, we discussed rule of law developments with member states' national authorities, with judicial and independent authorities, and again, with relevant stakeholders such as journalist associations. Last but not least, every member state had the opportunity to check its draft country chapters for factual accuracy. All member states have been closely involved, have actively participated in the process. They were all treated equally. We applied the same methodology to all and constantly ensure consistency. We made sure that this process was robust, transparent and as inclusive as possible. But let me also be clear that this report represents the Commission's own assessment. This takes me to the report itself. I repeat that we look at 4 key areas: the independence, quality and efficiency of justice systems, the anti-corruption framework, media pluralism and media freedom, and other institutional checks and balances. On the independence, quality and efficiency of justice system, we appreciate that in a number of member states, efforts are underway to strengthen judicial independence and reduce the influence of the executive or legislative power over the judiciary. For instance, the setting up of strengthening of independent national councils for the judiciary is a good example of how some member states have been making concrete efforts. But it is also true that judicial independence remains an issue of concern in certain member states. For example, we identified issues related to the capacity of councils for the judiciary to exercise their functions. We have also more structural concerns over an increasing influence of the executive and legislative branch over the functioning of the justice systems, including constitutional courts and supreme courts. In terms of quality of justice, the current pandemic has highlighted the importance of digitalizing justice systems. Many initiatives are ongoing in member states to deliver real improvement for the users of justice systems. Some justice systems are already equipped with the technology to operate remotely, to carry on communicating with lawyers and other court users. These are good practices to share. We appreciate that several member states have adopted comprehensive new anti-corruption strategies or revised existing ones. What will, however, be key is that their strategies are effectively implemented and monitored to ensure that progress is made on the ground. In some member states, measures have been introduced to strengthen institutional capacity to fight corruption and to reduce obstacles to effective prosecution. But it is also true that our monitoring shows concerns in several member states about the effectiveness of the investigation, prosecution and adjudication of corruption cases. This includes concerns that high-level corruption cases are not systematically pursued. About media pluralism and media freedom. First thing first, the independence and competence of media authorities is enshrined in law in every single member state. That being said, there are red flags in some member states with regard to the political influence on the media, a lack of transparency when it comes to who owns media, a lack of pluralism in the media landscape, and risk to journalists and other media actors when doing their work. The fourth and final area of our report are institutional issues linked to checks and balances. On the positive side, there is a healthy debate on strengthening legal and constitutional safeguards in some member states. In a number of member states, reform processes are underway. In particular, they concern the opening up of new channels for citizens to challenge the exercise of executive and legislative power. The advice of international expert bodies, such as the Venice Commission, can support today's processes. The COVID-19 pandemic also provided some good examples of well-functioning checks and balances. Parliamentary scrutiny helped frame emergency response. The measures taken were often reviewed by the courts. However, we also identified a number of rule of law related concerns in this area. In a few member states, we see repeated recourse to expedited legislation in Parliament or emergency ordinance from the government. Moreover, in some member states, civil society lacks an enabling framework, faces diminishing space to operate, legislation that limits access to foreign funding or smear campaign, to name but a few examples. Where do we go from here. The comprehensive European rule of law mechanism is more than the report itself. What we want to achieve through this report is a true dialogue at EU and at national level with the European Parliament, the Council, national parliaments, as well as European and national stakeholders. This dialogue is a key of the mechanism. We want to promote a rule of law culture across the European Union. As you may know, the German presidency intends to have a rule of law dialogue in the Council based on our report. There will be 2 discussions in the General Affairs Council, a horizontal discussion covering general rule of law developments in October, and country-specific discussions addressing key developments in specific member states in November, 5 member states.
We will also be presenting the report to the European Parliament, which must be fully involved in this work, and we also need to ensure that progress is made in the discussions at national level. And I'd like to invite national parliaments, stakeholders and civil society to discuss the conclusions of the report. To support the process, we are planning on acting at national level, going to a number of national parliaments in person or being present via video, depending on how the crisis is going, to discuss the conclusions of the report there. I think that the rule of law mechanism, I would say, doesn't end with the publication of the report today. Everyone, politicians, academics, experts, CSOs, journalists, and all EU citizens have to play a role. It's the job of all of us to breathe life into this mechanism so that it becomes a real cornerstone of the protection of our democracies. And I'd like to end by thanking all those in the Commission services and in the Secretariat who've worked very hard to ensure that we've been able to put this into place, and we will be doing exactly the same for the publication of the second report. Thank you very much. After this press conference, I would just tell you that we're also going to have a technical briefing to go into a bit more detail on the report. And now, if you'll allow me, I'd like to open the floor for any questions you may have.
System by raising your hand if you have a question for us. And yes, I already see a question from Lily. Lily, go ahead. Lily, are you there?
Hello, can you hear me?
Yes, all good.
Yes. Great, thank you. I have a question that goes both to Vice President Jourova and Commissioner Reynders. You talked a lot about this report being preventative and about detecting problems before they become more serious. But in some member states, there have been concerns raised for many years, and in one case in particular, for over a decade. I was just reading quickly through the Hungary and Poland reports, and I noticed that there are a lot of references to things that Greco, the Venice Commission, and the European Commission itself have raised many times. So I was wondering, is it too late for this kind of assessment? If not, what concretely can this report achieve? And at what point is dialogue simply not enough? Thank you.
I will start very, very shortly. Well, indeed, we try to open a new chapter in defending and promoting the rule of law in the EU. Indeed, we have in our toolbox the possibilities to address the already existing serious issues, the violation of EU law and systemic breach of the rule of law, which is addressed by Article 7 and infringement proceedings. But this new chapter is, as you said yourself, about early detecting and possible prevention, where we believe that there is never late for the dialogue when we see the early indication that there are some negative trends in the respective member states. So we are coming with a new tool which should be complementary to the tools which we are already using.
I want just to confirm that it's an additional tool, so we'll continue to use different other tools. We are going forward with the Article 7 procedure, we are going forward with infringement proceedings, and there are, for the moment, discussions about a possible other additional tool, I mean conditionality in the framework on the MFF and the Next Generation EU. But the main important element of such a kind of report in a process for many years, because it's the first one of a long series of reports, is to install, I said, a real culture of the rule of law, but to install a real debate, maybe first at the national level. It will be important to discuss in the Council, to discuss in the European Parliament, but the most important element is to take on board the authorities, but also the civil societies in all the Member States, and to try to engage a real discussion on the values in all the Member States. So it's true that it's a preventive tool, not only because we are showing the reality now, but because we are trying to start a real discussion. It will be long, it will be year after year, but it's very important, and it's an additional instrument because we have, I said, other instruments to continue to work on specific cases.
Thank you very much. The next one on my list is Athanasios. Athanasios, if you are there, over to you. There you are.
Thank you very much. Bonjour. I read the chapter for Cyprus. I don't see a specific mention on the issue of golden passports, although many might think that this thing pertains to rule of law, corruption, transparency, checks and balances. Why is that you're not mentioning it specifically, or is it in some place that we cannot really access it right now? Second question on Greece, I read the concerns you have on the judicial system, but I don't see a specific mention to the time that is needed for a final judgment. You may already know that in order to get a final judgment in a civil court or in an administrative court in Greece, you might need more than 7 to 10 years. How are you going to address that? And to speak in legal terms, what's going to be the remedy for such a deficiency? Thank you.
Thank you very much. Commissioner.
So maybe first of all about the justice system and the length of the procedure. First, we have a justice scoreboard where we publish different data about the situation in all the member states. And in the report, you will find a lot of remarks about the evolution in all the member states, about the length of the procedure, also in civil or commercial cases, and not only in criminal cases. And of course, I've said that we will insist on some new evolutions, and first of all, the digitalizing of the justice system. It will be maybe a part of the solution. So there are many concrete examples of this. And I want to confirm also about the so-called golden passport. Of course, we have put a framework about the report. It's possible to discuss for the next years about the way to have an evolution in the different elements that we'll take on board in the 4 chapters or in others. But of course, on such a situation also, we are continuing our action, and I've said already some weeks ago that we are thinking about possible infringement proceedings or possible reflections on the legislation. So we are using all the tools, not only the report, but also other tools about such a kind of situation in one or more member states.
Thank you. The next one on my list is Natalia. So Natalia, I hope you are there and we can hear you.
Hello, do you hear me?
Yes, all good. Go ahead.
Okay, good. Natalia Segura from the Catalan News Agency. A question on Spain. I would like to know if any organization that participated in the consultation raised any concerns about the imprisonment of the Catalan independentist leaders or any issue related with the Catalan conflict. And if any raised this issue, I would like to know why you decided not to include this in the report. And secondly, you just mentioned that at the General Affairs Council in November, you will discuss about the situation in 5 member states. I would like to know which 5 member states they are and why these 5 are being discussed and not the others. Thanks.
Natalia, the sound wasn't great. I hope that the Vice President and the Commissioner captured the essence of your question. Otherwise, I will give you back the floor to explain.
No, I've tried to capture. So maybe the last one is very easy with the list. So it will be a debate, a peer review at the level of the General Affairs Council on 5 member states in particular order: Belgium, Bulgaria, Czechia, Denmark, Estonia. So, and we are trying to be sure that it will be possible to continue in the same way during the Portuguese presidency and during the Slovenian presidency. And so in between 2 and 3 years, we will have a peer review on all the member states. So it's quite important to insist on this. And of course, as regards Catalonia, I will ask maybe in the technical meetings to say more about the remarks from different stakeholders, because of course I don't have the 200 remarks in my mind, but you know the position of the Commission about the situation, and it is and remains an internal matter for Spain, which has to be dealt with in line with its constitutional order. And the European Commission fully respects the Spanish constitutional order, including the decisions of the Spanish judiciary. And the rule of law report, we have said it, focused on systemic rule of law issues related to the justice system and other elements in other chapters. And finally, of course, you know that also we don't comment on individual cases. But about the remarks from the stakeholders, it will be possible, I'm sure, from the DG Justice to give more information about what were the reaction of some stakeholders. But the position of the Commission is very clear about such a case.
Indeed, so for more detailed questions or of a technical nature, I refer you to the technical briefing which will take place just after this press conference. In the meantime, I will now give the floor to Samuel. Samuel, are you there?
My question is on the timing of your audits. Just before the European Council, there's key issues going to be addressed there. Are you not concerned this might spill over into discussions there? And as this report has rather stark messages for a number of countries, including Hungary, do you think this could have an impact on the adoption of the long-term budget for the Union? Because there was a condition there on respecting the rule of law and the budget. There were some difficulties with the sound quality, but I hope the commissioners managed to grasp the issue addressed.
Yes, I hope there is no problem with the quality of the answers. I will just confirm that, at least from my side, there is no concern about the timing before the European Council. I think that the rule of law is the principle which we should discuss more often without the concerns that it will block this or that, because this is the general and very important, existentially important principle and value for the EU. So no, I don't have any concerns about the timing.
Just to reiterate that every year we publish a report on the rule of law, and it will come out on a certain date, and there will always be other debates in the EU on other subjects. We're not going to call off work based on these discussions, otherwise we'd never have our annual reports every 5 or 6 years based on how discussions go and how the Council organises its work. We've seen that sometimes it's very difficult to set a date given the date of the Council, which also had to be postponed, and so we also have to meet with the Parliament or the Council itself. There's no particular reason to make any change in our timetable and to publish our report on the rule of law based on other meetings taking place elsewhere. Thank you very much.
On my list is Thomas, hoping that you are there and we have good sound from you.
I am. I hope so too. So Thomas Kutschka from Frankfurter Allgemeine Zeitung. Commissioners, I have a question that is related to your report. This morning, the German presidency received a mandate from Coreper to negotiate with the European Parliament on a new rule of law conditionality. This will be done on the basis of a proposal presented earlier this week, with which you are certainly familiar. Now, this proposal is a watered-down version of the 2018 Commission proposal, it no longer has any reference to general deficiencies in the rule of law sector and substantially changes the threshold for initiating sanctions against a member state. Now, in the context of your review, which of course is about general deficiencies, how do you assess this proposal, and do you see a need for more substantive or for a wider threshold to initiate possible sanctions? Thank you.
Thank you very much. Vice President.
Yes, thank you very much. I can start by a very positive tone that I am very glad that the rule of law conditionality is negotiated and that the member states are taking it very seriously, because the principle is clear that there must be guaranteed the respect to the principles of rule of law and protection of EU financial interests in all the member states. We owe this to the European taxpayers. So I am glad that we are in this advanced stage of negotiations. Of course, the Commission adopted and presented for negotiations something which was stronger. As for the formulations, as for the voting system, which might trigger the application of the sanctions. But as far as I know, what was endorsed today by the Coreper, we have to count with some reformulations, and also the voting system was in lengthy debates for several months. So I will speak on behalf of myself. I can live with this proposal, which is changing the voting system, because everything will be better than unanimity, which will not lead anywhere and which would create another Article 7 situation. So I am glad the negotiations are proceeding.
Thank you very much. I will now give the floor to Georgi, hoping that he is there. There he is.
Hello, Vice President. Hello, Commissioner. I hope you can hear me. Bulgarians are protesting in the streets for a third month now, every evening, and they're protesting against the widespread injustice. They are protesting against the mafia. They believe that the justice system is not working, despite the mechanisms that the Commission has had to monitor this justice system. They perceive that the judiciary is corrupt. They perceive that the prosecutor is working for the government and the mafia. And in terms of press freedom, and it's good that you address the issue of press freedom, Bulgaria occupies 111th place in the world according to Reporters Without Borders. It's not only the last in the European Union, it's worse than in candidate countries. And the people in the streets tell the European Union, stop funding our mafia, don't spend EU money for this corrupt regime. So please, beyond your report, what is your political message to the people in the streets? Thank you.
Very much. Vice President or Commissioner?
So, thanks for the question. I want to say that you will find first in the report many remarks, concerns and problems that we have seen in all the member states and certainly in Bulgaria. So please read the report and the country chapter about Bulgaria to see what the reality is in the way to organize the next steps and the discussions on such an issue. But of course, there are other tools we have set to continue to insist on the necessity to organize reforms in some member states. And about Bulgaria, of course, one of those tools is the CVM. And so it was very clear in the previous documents about the CVM that we have had maybe some progress in the last years, but we insist on the necessity to reforms different kind of part of the organization of the public authorities, and certainly in the justice system, in the fight against corruption. But again, first of all, it's needed maybe to read the report on the Bulgarian situation to better understand what are our concerns, and it will be the same about the CVM like we have organized in the last years.
Thank you very much. Vice President?
Yes, I'd like to add just a few things, because indeed, as Didier said, there is still the CVM mechanism ongoing. As you know, there were plans to lift it, but there is still unfinished business for the Bulgarian authorities, especially for the government. The reforms have to be finalized. There was always from every surveys, there was always a very clear message from Bulgarian people that the trust to judiciary and to institutions is very low. And on specific question whether the EU should continue the CVM pressure or the push on the reforms, the support of the Bulgarian people have always been very strong. So now we are continuing the CVM. We are now reflecting the objective picture of where we are in Bulgaria, be it in anti-corruption or media sphere and judiciary as such. I think that this is something which the Bulgarian government and the parliament should deal with the findings of the reports, and of course to take it very seriously, because when the people are expressing such dissatisfaction and such mistrust and very clear feeling that there is not possible to receive justice from the state, then it is a serious thing to be considered by the national authorities. So this is not additional criticism. We have always offered, we have been always offering very active support for the reforms in Bulgaria over the CVM process or through different possibilities. So the Commission stands ready to support and help.
Thank you very much. The next on my list is Krzysztof, hoping that he is there. Krzysztof?
Yes, I'm there. Can you hear me?
There you go. We can hear you. Go ahead.
Thank you very much. The question to both of you, commissioners. It seems that there is nothing new in the report concerning to Poland, and I was wondering how it might help in the situation regarding to the rule of law in Poland or in Hungary, when according to Commission own assessment, the situation on the rule of law is the worst. So what's the added value of this report, this new mechanism? Thank you very much.
Thank you.
But maybe first of all, I said that the first add value is to put together all the data that we have about the situation in all the member states, also in Poland, in the different chapters that we have examined during the process. And that's very important, because that gives a capacity to organize a real debate on the rule of law in one member state, like at the EU level, and we will work on it. But about actions, of course, the dialogue will be an important action, but again, we will continue to work with infringement proceedings, and we have introduced some infringement proceedings, and we have started some procedures about Poland, but we'll continue also to discuss at the Council level in the way of the Article 7 procedure, because you know that it was introduced by the Commission some years ago, and we continue. We have organized a state of play at the Geneva Council some times ago in the month of September, and we will continue maybe with hearing at the end of the year. So again, it's one additional tool to have a very comprehensive approach to the situation in all the member states at that EU level, but it's also possible to continue to work with all the instruments that we have in our toolbox.
Just one additional sentence, and we listened to the calls from Poland and Hungary, who for a long time were telling us, look at other member states, compare all the systems. And the Commission had to agree with the need to have a better and broader picture on the rule of law situation of all the 27 member states. So I think this is a very valuable start, that we have the reports and we can compare the systems.
Thank you. I will now give the floor to David Careta. David, are you there? Do we have...
Allô, vous m'entendez?
Oui, nous t'entendons.
Hello, can you hear me? Yes, we can hear you. Go ahead.
Ufficale Italian Radio. A first question to Vice President Jourova. I'm wondering in which countries the cocktail is toxic. To be very concrete, on the basis of the report, would you activate the mechanism which is discussed at the Council right now? And if yes, for which countries? In question, Commissaire Reinders.
And then a question, Commissioner Reinders, on Italy. I read the summary on my country, and I've seen that there are a few minor problems and so on and so forth, but I get the impression that the analysis carried out of the situation in Italy was above all legislative, not to do with practice. For example, with the media, you said there are no effective mechanisms to deal with conflict of interest. But if you look at how public TV and radio work in Italy, where politicians decide almost everything, there's nothing in the report on that. Regarding the justice system, it says everything's fine, it's very independent, but we've seen there was a recent scandal that there are judges who are basically involved in political activities because they've been opening investigations against political opponents. So, I mean, don't you see a problem with what's happening in practice in member states as well, in Italy in particular?
First, on the first question.
Yes, first of all, I would never say that any member state is toxic. So, just the rejection of this language. It would be highly speculative if I take the results of this report and say this and that state could qualify for application of the sanction on the rule of law conditionality mechanism, because there are new additional criteria in the rule of law conditionality proposal. It's one thing. The second thing, there will have to be very thorough assessment from the side done by the Commission on the basis of this additional and slightly different criteria from what we work with in this rule of law report. Sorry for being technical, but I think it has to be explained that the rule of law report, which we are presenting today, will not serve as this assessment. There will have to be a new, very thorough assessment which will look into the conditions for protecting the EU money in the respective member state. Also, what needs attention on the proposal is that, if I count well, there will be 4 stages in the process. First, the assessment of the Commission based on the facts and on the objective criteria. The member states will have a possibility to respond and explain, so it will not be one-off decision overnight, which was never the case for the Commission anyway. The second or the third stage after we receive the response from the member state, if I understand well now the updated proposal, there should be also European Council debating the concrete case, concrete situation, because this is very serious. To apply the financial sanction, well, it requires also debate of the leaders, and then only should be the relevant council coming with on that case, and the vote which we are discussing should be applied. So we cannot use these reports, and we do not want to use these reports for shortcut assessment, which could lead to financial sanctions. And let's not call it sanctions, by the way.
Very much. Maintenant sur la situation en Italie.
And now the situation in Italy. Well, regarding the chapter on Italy, I would remind you that we applied exactly the same methodology in Italy as we did elsewhere, and we commented on and analysed the same things. Now, regarding the media, you mentioned the issue of conflict of interest, and that is something which is highlighted, and it does pose a number of problems, as it does in other member states too. On legal aspects, I'm not going to speak about individual cases, as I've said on other occasions, but of course the resources dedicated to the legal system and the length of the procedures, these are things which are mentioned in a whole host of reports. I think there's information on the situation in Italy in the Rule of Law report, and also on the Justice Scoreboard, which we published. And of course, if you so wish, you can ask some more detailed questions about the situation in Italy in the technical briefing, which I think will be taking place shortly afterwards. Yes, indeed, straight after the press conference.
To Catherine, hoping that she is connected.
Yes. Hello. Hi. Catherine Fiore, EU reporter. My first question would be for Vice President Jourova. Do you have any comment on the letter sent by Viktor Orban where he calls for your resignation, given your comments in an interview describing Hungary as a sick democracy? And for Commissioner Reynders, you say that you will look at all tools and that the EU has to make use of all tools. But in the area of state aid, I mean, in Poland, for example, we see the ruling party giving significant funds to a public broadcaster that is really acting as a propaganda channel for the government. And state aid rules on public service broadcasting do say that you're allowed to fund these broadcasters, but they have to be impartial, they have to be fair. So is this something that you could make more use of?
Thank you, Vice President.
As for the letter of Mr. Prime Minister Orban to Madam President Ursula von der Leyen, I don't have any comment. I suppose that the letter will be replied in due time. Thank you.
Indeed, and yesterday we set out very clearly the position from the President on it, pending that reply. Now, Commissioner.
And it was confirmed by all the colleagues at the college meeting, I want to add. Just about the state aid, it's not just a problem of state aid. First of all, it's a problem of financing and funding of the media. It's the problem of direct financing and funding sometimes in some member states, or the state advertising. It's also a real difficulty sometimes to see that there are more advertising to some media than to others. And of course the state aid, and certainly during the COVID-19 crisis, it was also an important issue because we need to have a fair treatment of all the different actors. So first of all, we try to verify what the situation is at the national level, and you will find a lot of remarks on the funding of the media in different reports. We try to see if it's possible to have a legislation at the national level on that, to have a fair treatment, and of course it's very important to have a fair treatment at the European level when we receive some proposal of state aid, and certainly in the media it's very important again to have a fair treatment about competition, but about also the pluralism of the media in one of another member state.
Thank you very much. I will now give the floor to Marcus. Marcus, are you there?
Yes, I'm here. I hope you can hear me.
Yes, go ahead.
Good. I would like to know how the discussion in the college today went. Did a commissioner force a vote on the report? And if so, who voted against? And if there was no vote, were there objections from commissioners? And if so, who objected to what? Thank you.
Thank you.
Yes, thank you very much for the question. We had a very good discussion. It was opened by the President, and we continued, Didier and me and the colleagues Thierry Breton and Eva Johansson, who are the co-creators of the reports. There were mainly the words of support, and there were also some objections, but the result is that the report has been adopted by the College.
Thank you. I will now give the floor to Maria. Maria, est-ce que tu es là?
Yes. Hello, can you hear me?
Yes, we can. Go ahead.
Great. Thank you. Maria Udrescu from La Libre Belgique. I had, first of all, a question for both commissioners. Don't you think it could be risky to put, punctual concerns and systemic problems in the same report, kind of, on the same par? And secondly, I mean, on systemic problems, we know what these problems are. They have been a subject of debate for years, and without, any concrete results in a sense that they are still there, as we can see in the report. And, dialogue hasn't helped. As you can see, Poland is still disrespecting, decisions of the ECJ, while Viktor Orban is now, asking for the resignation of a vice president and refusing to get into any kind of dialogue with the Commission. So I'm wondering, what kind of actual dialogue or additional dialogue you're hoping to stimulate with this report. Thank you very much.
Thank you, Vice President.
Thank you very much. We have always tried to keep the dialogue, because the dialogue is the core principle or condition for democracy and cooperation. So this is a general comment on whether it is risky or not. Of course, we are covering very sensitive topics in these reports. That's why, from the beginning, and I'm sure Didier will add his views on that, that's why we were so careful to come with methodology which will measure and assess all the member state situations by the same criteria, that we really tried hard to keep the process very transparent and very inclusive, so that nobody is surprised by the result at the end. The second thing, because the problems in the countries you mentioned, where we have the Article 7 and rich infringement activity, came the problems, if I remember well, sometimes a kind of out of the blue, that suddenly something happened, some law was adopted overnight, and the Commission had to react on that. That's why we want to avoid these out of the blue situations. That's why we want to have this annual assessment in cooperation with the member states to understand the situation and the trends, so that we do not have any further surprises. Didier.
But to be concrete, the fact that we are explaining in the report some punctual issues or more systemic issues is in line with our working methods. We have applied the same working methods for all the member states, but if there are some systemic issues in some member states, we need to explain that. If it's just punctual, we explain also. So it's not due to a decision of the Commission to do that or not. It's just about the situation, concrete situation, the picture of the situation in the member state. Is it with an effect or not? We have an effect. Article 7, it's possible with the Article 7 to maintain a political debate at the level of the Council, but also to have an influence to stop some proposal of reforms, and we have some examples of that. But more than that, you spoke about the European Court of Justice. It's very positive that we have received reactions from the Court of Justice on the basis of the infringement proceedings. So it's possible to block some evolutions in some reforms. And to take an example, when you have a direct effect to some individuals, I'm thinking about the disciplinary on the judges in Poland, it was possible in February to go to the court for interim measures, and 2 months later, in April, it was possible to receive a positive answer from the court and to suspend all the procedures. So there is an effect. Of course, it's an additional tool, but we have other instruments to have an effect. And is it possible to have a dialogue? Of course we will have a dialogue. We have a dialogue with all the member states. We will continue between the Commission and the member states. What I said, we will have the same dialogue at the Council level, in the UN Parliament, but it will be also important to go to the national parliament in all the member states.
Thank you very much. I will now give the floor to Mose. Mose, are you there? Are you there?
Yes, thank you, Nana. I hope you can hear me today. My question to Vice President Jourova is, you said that, also the Commissioner said that there has been a close consultation with the member states, and also were given the opportunity, let's say, to check the factual accuracy of their parts. So my question would be, if, for example, Hungary accepted, let's say, that factual accuracy in your assessment, and then, as you said, I mean, there is an issue about how to define the rule of state or how to describe the lack of rule of state. I wonder if you would agree that the term illiberal democracy, which in fact I think has been used by Prime Minister Orban himself, if that somehow would cover, let's say, the lack of, let's say, accountability, transparency, checks and balances between democratic elections. Thank you.
Vice President.
In fact, I never saw anywhere the definition of what is meant by illiberal democracy. When I look into the treaty and I look at the Article 2, I think the principles and values of the EU have been there, and all the member states have committed to respect all these principles and values. So I don't know the definition. As for the factual assessment, we did our best, as I said before, to use the methodology to be able to make as precise as possible assessment, but we have to face the fact that we are not in fiscal policy where we are counting money. Full respect to our colleagues who have easier life in the world of economy where they can compare the figures. We do not have such a luxurious position. We work with something partly abstract, also very sensitive. We have the duty to do the factual assessment using all the data possible and to try to be as objective as possible. Of course, there were member states which had factual comments, and I will leave it for Didier to say what you have done with them.
The technical briefing afterwards, which can focus more on details.
Thank you. We have said, first of all, about the standards. What are the reference? Because there are many declarations from many people around the rule of law, but we have taken into account the treaty, and Article 2 is maybe the basis of the reference that we have taken. But then I said we have also the case law of the European Court of Justice, of the European Court for Human Rights, the Council of Europe have also some very clear standards at a broader international level, but also for the member states of the EU. So it's very clear that we are working with those elements and not with comments coming from different kind of actors. And the second element, of course, I repeat, we have had a very good collaboration from all the member states at all the stages. But not only, we have worked with many other stakeholders and with many other partners. At the end, it was possible for the member states to try to correct some factual accuracies. It's logical. And we have received remarks from all the member states. More remarks maybe from certain than for others, but remarks from all the member states. And when it was about factual issues, of course, we had the possibility, and we did that, to agree and to change some elements, but not on the assessment, of course, because I repeat, the assessment is an assessment from the Commission. It's not a joint assessment between the Member States and the Council. It will be possible at the Council level to organise, I said, the discussions on the basis of our report, but it's a clear report from the Commission, organised with a very good collaboration with many partners and certainly the Member States, but at the end, it's a real assessment from the Commission.
Thank you very much. I will now give the floor to Katalin. Katalin, are you there?
Yes, Dana, thank you very much, Katalin Halmai, Hungarian daily paper Népszava. A question to the Vice President. Since one of the pillars of this new mechanism is holding dialogue with member states, and there is a lot to discuss with Hungary, how do you see the possibilities to keep a dialogue with the Hungarian government in the light of Mr. Orbán's letter where he said that the Hungarian government will suspend political contacts with you? Thank you very much.
Thank you. President?
Yes, I cannot predict what will be in the answer of Madam President, and I can only tell you, confirm, I think what is quite clear, that the Commission will never close the door to anyone for the dialogue. When I was last time in the Parliament, in the European Parliament, I heard the voices that when I speak about the need to continue the dialogue with the countries where there are problems with the rule of law, that I was criticised for the conviction that we can improve things through the dialogue, because there were voices that we should not stop speaking about the dialogue and come with the sanctions. I don't believe this is possible, and this is feasible and this is the right way to go. So the Commission will not close the door for the dialogue, but again, I will repeat myself, I cannot predict what will be in the letter, and I have to confirm that I was very grateful yesterday to the President that she supported me.
Thank you. I will now take the last three questions of this press conference. The next on my list is Philip.
Hi.
We had Philip briefly, yeah.
Hi, can you hear me?
Yes, we can. Go ahead.
It's fine. Okay, thank you. My question relates to the rule of law in Greece and also to the European Commission. In Greece, we have countless indications that the rule of law is violated on the Greek islands with regard to the rights of refugees and migrants. Now, the European Commission, as the guardian of the treaty, has the obligation to investigate and, in case, to launch infringement procedures. So why haven't you launched an infringement procedure on the situation on the Greek islands, in particular with regard to the reception directive, reception condition directive? And secondly, if I may, more broadly, how big is your margin of discretion in this field? So can you say, well, we try otherwise to have a solution on this matter, we don't launch an infringement procedure if you want to? Thank you.
I will leave it to Didier because we said that country-specific question will go to him. But on what are the moments when we are deciding whether to launch the infringement procedure or not, it's not always easy, but we have to respect ourselves, the rule of law principle, and to stick to our competencies. So we have to do a proper legal check whether we have the legal competence and whether there is obvious breach of the EU law in the respective country. When these conditions are in place, then it's our obligation to formulate the file and to ask the European Court of Justice for the interpretation. Thank you.
No, just to add, of course, we will have the opportunity to discuss more about the specific country chapter later in the afternoon. But first of all, you will read in the document also about Greece our remarks about the situation and the remarks that was made by other than the European Commission on the situation. About the infringement proceeding, of course, there are investigations about the implementation of the EU law and a lot of directives. But if there are some negative results of such an investigation, the Commissioner in charge will come to the College to see if it's possible to introduce an infringement proceedings, like in all the different other issues. So we are working in the same way for such a kind of situation and for others. But first of all, of course, we need to have elements coming from investigation about, I repeat, the correct implementation of EU law, because it's that it's possible to send to the European Court of Justice for a decision.
Thank you very much. I will now give the floor to David.
Thank you. Hello, David Price, Your Democracy. Hello, Vice President. Hello, Commissioner. There's an elephant in the room which nobody's talking about, and that is Brexit. The United Kingdom left the European Union because of a lack of transparency, human rights, and the democratic deficit. And the articles of the Lisbon Treaty were actually rejected in referendums in France, Netherlands, and would have been in maybe 6 other countries when they were part of the Constitutional Treaty. They were reimposed, not only without a referendum, but against the referendum that had been previously held. So we're now faced with a situation where the legitimacy of the European Union needs to be properly re-established so that countries like Norway, Switzerland, Iceland, which are strong democracies, will feel happy to join. How do you see the legitimacy of the present situation being completed. So this unfinished business of the legitimacy of the present treaty can be agreed in relation to the human rights of the population as distinct from political parties.
An almost philosophical question. So I wonder if the Commissioner or the
maybe, if I may, we have.
How much time do we have for
exactly.
that?
Yes, it may be for a very long time to answer the details, but just to say that we have 27 member states, and they agree on the treaty about through different procedures, but we have 27 member states. First, the legitimacy. It's true that we have the legitimacy to present a report on the rule of law in the 27 member states. It's not by coincidence that we don't have a report on UK, because due to the Brexit, of course, we are not organising the same process. But we continue to work on the rule of law on the 27, and you mentioned different other countries. One of the main elements of the report is to do the job at home in the European Union, because if we are doing the job at home, it's possible to discuss with neighbouring countries, with candidate countries, with all the international partners about the rule of law. But it's a precondition to do the job at home. And of course we are doing that, but again in the 27 member states, so we don't have 28 country chapters because we have had the Brexit.
Thank you. Okay, very good. Then I will give the floor for the last question to Griselda. Griselda, are you there? I know you waited for a long time.
Merci. C'est bon. Merci beaucoup.
Thank you. Griselda Pastor from Radio Española. I see you had a list of challenges for the Spanish judicial system. My apologies, but are those challenges, from your point of view, a problem for democracy? So the review of the Spanish judicial system, do you think that's a problem? In drawing up the list, do you expect there to be changes made? And if not, is it a procedural risk? We have this new mechanism that has to be activated in terms of the EU subsidy monies and the rule of law. Could this be a problem if the issues in the list are not addressed? Thank you. Well, on the comments made in the different chapters, and in this instance for Spain, we've tried to explain in what areas there is room for improvement. You spoke about potential infringement proceedings. Well, of course, proceedings are possible if we note amongst the list that you referred to that there's a shortcoming in terms of EU law. So if there's a problem with existing EU legislation. But there's a list where progress could be made. Now, I said earlier that there was a possibility for improvement in almost all EU countries. We've had just issues such as systemic issues. I'm thinking of Article 7 here. And then the issue of conditionality for financing and EU funds. Well, let's wait until we have a document outlining the proceedings and see what would be borne in mind there. But we didn't at all draw up a list based on each member state with a view to proceedings in the future. We'll start our work on such issues down the line. Thank you.
Yes, I will just say that the rule of law is the big, essential, existentially important principle for each member state and also, of course, for the European Union. And this big thing is created by many, many smaller things, sometimes details which might seem unimportant, but the cumulative power of those smaller things means that either you have high quality rule of law principle or you have the gaps which might cause big problems. So we are focusing also on the details and on the matters. So we might see the negative trend, and indeed the report is descriptive, but it is the opening the door for the dialogue and clarifications, and also it doesn't mean only for the member states, for the Commission, but also for the member states to look at each other, how they do things and what are the results. This is very similar how it works with the Justice Scoreboard. It also is appreciated after years of reporting that the member states have better information about how their partners in the Union are approaching things and are solving problems.
Thank you very much, Vice President. Thank you very much, Commissioner. We need to bring this press conference to an end. I'm sorry, I know that there were more questions in the pipeline, but you're welcome to ask them at the technical briefing which follows just now, so please stay tuned. Thank you. Have a good afternoon.